Detention under Republic Act number 9372. Number 1. What is Republic Act number 9372? An act to secure the state and protect our people from terrorism. This act shall henceforth be known as the Human Security Act of 2007. This law was amended by Republic Act number 11479, otherwise known as the Anti-Terrorism Act of 2020. Number 2, does the time for delivery of detained person prescribed in Article 125 apply to suspected terrorists who are detained under Republic Act number 9372? A person charged with or suspected of the crime of terrorism or the crime of conspiracy to commit terrorism shall be delivered to the proper judicial authority within a period of 3 days counted from the moment the said charged or suspected person has been apprehended or arrested, detained, and taken into custody by the said police or law enforcement personnel. Without the police or law enforcement personnel having said person in custody incurring any criminal liability for delay in the delivery of the detained person to the arrest of the suspect must result from the surveillance under Section 7 and Section 27, Section 18 RA number 9372. Ang taong dinimanda o suspitsado sa krimen na terorismo o sa krimen na conspiracy to commit terrorism ay kailangan masampahan ng kaso sa loob ng 3 araw mula noong ang dinimanda o suspitsadong tao ay nahuli, kinulong at nilagay sa kulungan ng mga pulis o alagad ng batas na hindi maglalagay sa kanila sa pananagutan kriminal sa pang-antala ng pagsampa ng mga sospek ay kinakailangang bunga ng pagmamatiyag sa ilalim ng Section 7 at pagsisiya ng mga deposito sa bangko sa ilalim ng Section 27, Section 18, RA 9372. Number 3, under RA 9372, who must be notified before a suspected terrorist is detained. Before detaining the person suspected of the crime of terrorism, the police or law enforcement personnel concerned must present his or her before any judge at the latter's residence or office nearest the place where the arrest took place at any time of the day or night. Bago ikulong ang taong suspitsado sa krimen na terorismo, ang mga pulis o alagad ng batas ay kailangan maipresenta siya sa kahit sinong huwes na sa lugar na kung saan nakatira ang huli o opisina na pinakamalapit sa kahit anong oras, araw man o gabi. It shall be the duty of the judge, among other things, to ascertain the identity of the police or law enforcement personnel and the persons they have arrested and presented before him or her, to inquire of them the reason why they have arrested the person, and determine by questioning and personal observation whether or not the suspect has been subjected to any physical, moral, and psychological torture, by whom and why. The judge shall then submit a written report of what he or she had observed when the subject was brought before him to the proper court that has jurisdiction over the case of the person arrested. The report shall be submitted within 3 calendar days from the time the suspect was brought to his or her residence or office. Isa sa mga tungkulin ng WES ay ang pagtino sa pagkakalanlan ng mga pulis o alagad ng batas at ng tao o mga tao na hinuhuli nila at iniharap sa kanya para matanong sa mga kadahilanan kung bakit nila hinuli ang tao at alamin sa pamamagitan ng pagtatanong at personal na obserbasyon kung ang suspect ay inilagay ba sa pisikal, moral at psychological na pagpapahirap sa kanino man o at bakit. Ang WES ay dapat magbigay ng nakasulat na ulat sa kanyang obserbasyon kung kailan ng suspect ay dinala sa kanyang harap patungkol sa kaso ng pagdakip ng tao. Ang ulat ay dapat ibinigay sa loob ng 3 araw sa kalendaryo mula noong ang suspect ay dinala sa kanyang tirahan o opisina. Immediately after taking custody of a person charged with a suspected of crime of terrorism or conspiracy to commit terrorism or conspiracy to commit terrorism, the police or law enforcement personnel shall notify in writing the judge of the court nearest the place of apprehension or arrest, provided that where the arrest is made during Saturdays, Sundays, holidays, or other office hours, the written notice shall be served at the residence of the judge nearest the place where the accused was arrested. Kagad-agad pagkatapos ng pagkulong ng tao, dinibanda o suspetsado ng krimen sa terorismo o conspiracy to commit terrorism, ang mga pulis o alagad ng batas ay magpasabi sa pamamagitan ng pagsulat sa WES ng korte sa pinakamalapit sa lugar na ginawa ang paghuli. Dapat na kung saan ang paghuli ay ginawa sa panahon ng Sabado, Linggo, kapistahan o pagkatapos ng oras pang-opisina o ang nakasulat abiso ay kailangan maibigay sa tirahan ng WES na pinakamalapit sa lugar kung saan ang akusado ay hinahuli. The penalty of 10 years and 1 day to 12 years of imprisonment shall be imposed upon the police or law enforcement personnel who fail to notify the judge as provided in the preceding paragraph section 18. Number 4, what is the period detention in the event an actual or imminent terrorist attack? In the event of an actual or imminent terrorist attack, suspect may not be detained for more than 3 days without written approval of a municipal, city, provincial, or regional office of a Human Rights Commission or judge of the municipal regional trial courts, the Sandigan Bayan, or a justice of the Court of Appeals nearest the place of the arrest. Sa panahon ng aktwal o sa puntong mangyayari na ang terorismong pag-atake, ang mga suspek ay hindi pwedeng makulong sa lagpas 3 oras na walang nakasulat na pahintulot mula sa pang-munisipyo, panlungsod, pamprobinsya, or reyon na opisyal ng Human Rights Commission o WES ng munisipyo, regional trial court, sandigang bayan o maestrado ng Court of Appeals na pinakamalapit sa lugar na ginawa ang paghuli. If the arrest was made during Saturday, Sunday, holidays, or after office hours, the arresting police or law enforcement personnel shall bring the person those official mentioned above that is nearest by place where the accused was arrested. Kung ang paghuli ay ginawa sa panahon ng Sabado, Linggo, Kapistahan o pagkatapos ng pang-opisinang oras ay umuhuling pulis o alagad ng batas ay dapat dalhin niya ang taong hinuli sa pamamahay ng alinman sa mga opisyal na nabanggit sa itaas ng pinakamalapit sa lugar kung saan ang akusado ay nahuli. The approval in writing of any of the said officials shall be secured by the police or law enforcement personnel concerned within 5 days after the date of detention of the person concerned. Provided, however, the 3 days after the detention, the suspect whose connection with a terror attack or threat is not established shall be released immediately. Section 19. Ang pahintulot na nakasulat ng alinman sa mga nabanggit na mga opisyal ay kailangan maitago sa mga pulis o alagad ng batas na nauukol sa loob ng 5 araw pagkatapos ng petsa ng pagkakulong ng mga tao nauukol, subalit sa loob ng 3 araw pagkatapos ng pagkakulong ng suspek na ang kaugnayan sa terorismong pag-atake o pananakot ay hindi papatunayan, kailangan siyang palayain agad. Number 5, what is the penalty for failure to deliver the suspect to the proper judicial authority within 3 days? The penalty of 10 years and 1 day to 12 years imprisonment shall be imposed upon any police or law enforcement personnel who has apprehended or arrested, detained, and taken into custody of a person charged with a suspect of the crime of terrorism or conspiracy to commit terrorism and failed to deliver such charge or suspected person to the proper judicial authority within the period of 3 days. Section 20. Ang parusa na 10 taon at 1 araw hanggang 12 taong pagkakakulong ay dapat ipataw sa mga pulis o alagad ng batas na humuli sa nagkulong sa taong dinimenda o suspitsado sa krimen sa terorismo o conspiracy to commit terrorism at nagbigong magsampa ng kaso sa korte sa loob ng 3 araw.